Good morning. Welcome to our Facebook Live broadcast. My name is Steve Altishan. I'm the Director of Client Partnerships here at Land and Home Family Law. And today I'm here with our lead estate planning attorney, Triston Dallas, to talk about wills. How you doing, Triston?
I'm doing well. Thanks for having me again, as always. Hope you're doing well there, Steve.
Well, I am. And looking at the end of the tunnel. We're finally, I think, coming around.
Yep.
So today, Triston, talking about wills, there seems to be this shroud of mystery that surrounds wills. There's arcane legal phrases, there's Latin terminology. I mean, even the name, the last will and testament.
Yeah.
But today, let's sort of cut through all that and try to make wills much more understandable for everyone, including me.
Mm-hmm.
And with that, let's just start with the basics. What is a will?
Yeah. And we've done a couple of these webinars and Facebook Lives and other podcasts and educational broadcasts in over the last several months, and we've talked about so many different issues that include the will. Right? We talked about issues with blended families and issues with retirement and those types of things, but we never really break down like just the bare basics of what is the will. And as you ask, it's funny because people look at it and think it's just a document, and at the end of the day, it kind of is. Will is going to be a legal document, a legal agreement, so to speak, that an individual can use to determine how their property is going to be distributed at their death, and how their assets or their affairs are handled, their estate is handled at their death. And what I mean by that is, it's not just saying, hey, my son gets my coin collection and my daughter gets X, Y, and Z and everything else goes to my wife. It's more than that. It will also give the individual an opportunity to lay out how their assets can go to their children if they're underage. It can list how their assets are used to pay back creditors and debts at their death. So there are several things that is possible within a will, more than just who gets what and how. It does get a little bit more in depth than that, but breaking it all down and funneling it all down to one thing, it's going to be a document that is going to be provided to the court in the event of your passing.
And let's start on that then. A document. Like you said, a legal document, and what that's presented to the court. So what makes a will, I guess I'd say, legally valid? What makes a will ready to be presented and legally, enforceable?
Yep. It's relatively straightforward. It needs to be in writing. It needs the person whose will it is must have legal capacity to make a will when they made the will. And it must be executed properly under the state rules. And really just means that the person, we won't get into the full details there and all the exceptions and all that, but basically the individual whose will it is needs to sign the will, and the will needs to be witnessed by at least two other individuals. That is not the person signing the will, or not the person whose will it is. That's the basics of what makes your will valid and ready for presentation to the court for probate in the event of your passing.
You're saying that it has to be, a person has to have legal capacity. And that, I know that's probably a legal term of art. Can we talk a little bit about what legal capacity just means in general?
Yeah, and that honestly could be a whole other podcast or Facebook Live event in itself. But simply, legal capacity just means you're 18 or older, and you're not incapacitated mentally or potentially physically in some way that would cause him to question your ability to understand what is being written in the document, or what has been the terms in the document. So if you have some type of mental illness, you're hospitalized in some way, obviously if you're unconscious in some way, there's no way you know anything that's in the document, but also something like call into question if somebody was inebriated whether it be alcohol or some other type of drug, that potentially could call in the capacity of the individuals to make the will. So yeah, I mean, there, like I said, there's a lot of other things that potentially go into it, but basically that's what you're looking for.
Just kind of you have to know what you're doing.
Yeah, you have to just be able to it's clear, and somebody couldn't say that you didn't understand what you were doing at the time you were executing or making your will. And it's different from somebody who can have a mental illness, you can have some other type of illness, or dealing with some other type of ailment, and doesn't mean your legal capacity is diminished or at a point where you are unable legally to make a will. Right. But that is kind of the basis in which legal capacity can be questioned.
Well, that makes sense. So the second thing you said was it has to be executed. Now I know a lot of people, when you look at a will, and at the end, there's seems like there's 42 different lines, for people to sign multiple times.
Yeah.
So can you tell us a little bit about, legally executed and witnessed, just a little bit what that's all about, what sort of the basics are involved in that?
Yep. Whoever's will it is needs to sign the document. And then contemporaneously, or even the two witnesses have to witness the actual testator, that's the person whose will it is, sign the document. They have to actually watch them sign it, or there's under the rules, it can be signed in advance and then acknowledge that that's their signature, and they signed it in front of the witnesses. And then contemporaneously, or at another time, the witnesses will sign an affidavit that just states that they actually witnessed the testator sign the document. Otherwise, and that becomes what is called basically self-proving, and we won't get into the details of all of that, but otherwise, what may need to happen is, without the affidavit or attestation of witnesses, then those witnesses are going to need to be tracked down so they can make a statement in court for probate to state that they actually witnessed the testator sign the will. So the simplest way is just you need to have witnesses at the time you sign the document, and they would need to attest to their witnessing of your signature. And that's basically it.
So the attesting part, is that where it generally gets notarized?
Yeah, so the witnesses' signatures will be notarized as to their attestation of witnessing the testator's signature.
And I think you said that makes it so that it can be sent to court, and the court can use those, that affidavit to sort of, acknowledge that this thing actually happened. And see, that makes sense, because, the one thing I'm thinking about is that, in a lot of cases, pretty much everybody who had everything to do with the will, obviously the person who wrote it,
yep,
quite possibly all the witnesses, and even the lawyer who was involved, are all dead. So having that document is really all you got left at sometimes to kind of show that it really happened.
Yeah. Yeah.
That makes sense. That gets to just a question everybody asks, and it's one of those old-fashioned arcane terms, a holographic will. You hear people ask, well, hold it, can't somebody, if someone just signs it in handwriting, doesn't that just make it valid?
Yeah, so again, won't get into the details of kind of all the exceptions, but there was a rule that was added in Oregon law within the last couple of years, in terms of if the proper execution of a will does not happen, there's still potentially a way to admit the will into probate. And we'll talk about briefly what probate is kind of, towards the end of our cast here, but ideally and technically, just having a will and then you signing it is not really enough to make it a valid will. And so then other steps need to happen in order to get the court to believe or to accept it as as a proper will. And just because you write the will doesn't mean that that's it. And so, like I said, we'll talk a little bit about probate later, but the court has to accept the will. And with the attestation that we talked about before, and the quote unquote self-proving, it makes things easier and almost automatic on that front.
Right.
Now,
Okay.
I'm relatively younger, and I haven't been.
Well, everybody's relatively younger than me.
But I haven't holographic and all that. That's just not something that is done nowadays. So
yeah, and that was one of the old myths. You could write a will, stick it in your drawer as long as it was in handwriting. People it had to be good. So, so we've got the idea of what makes a will valid, how you sign it. Now let's get to what's in a will. What sorts of things are in a will? Because what's required to be in a will, and maybe also what isn't required, but some of the other things that are typically put in wills.
Yep. Yeah. So at the end of the day, for the most part, your will doesn't have to have any specific type of terms other than it's clear as to who the person's will it is, and that they're creating this will under or with the legal capacity that we talked about previously. Other than that, for the most part, there isn't anything specific that needs to be in the will. Right. Now, there are some typical and regular clauses that you're going to have in the will. Things like, you're going to make a nominate for your personal representative or executor. You're going to make some declaration in terms of if you're married, if you have children, that type of thing. And then you can make specific gifts. You can, by saying like Bob gets X and Susan gets X and John gets X, you can make those types of designations. And then you can make a kind of a blatant, if you want to be, pretty simple, you can make a blatant just residual or residue gifting through the will and just say everything that I own after expenses and creditors are paid is going to go to X, Y, and Z. So you have some freedom there. And like I talked about earlier, it's those are the things that typically you'll find in a will, but it can be more than just who's getting what.
Sometimes in a will, I see a term, I hereby revoke any previous wills. Is there a reason that's in there?
Yeah. And a lot of times, especially as you get older, obviously you're going to look at your will, you're going to have updates and changes, rewrites and all of that. And so what you don't want is a situation where you have two wills and neither of them have been revoked. And now there's a question as to which one's going to rule. Now, generally you would think, well, I have one written in 2021 and I have one that was written in 1991, but your one in 2021 doesn't state that it revokes the previous will. Now you may have some continuity issues as one may conflict with the other. Right. And so normally you would want to have some type of language in the will that states you revoke all previous wills or codicils, so that it's clear that the newer will that you're writing and that you're executing is the only will that's going to rule in the event of your passing.
That makes sense. It seems like, again, clarity is really one of the fundamental things you're trying to get done in a will, so that there isn't these questions once you're gone.
Yeah. You want to be broad to cover as much things as possible in your will, based on your wishes. And everybody's going to be different, but yeah, you're right. You want to remove all confusion for as many things as possible.
Let's talk a little bit. You mentioned someone to kind of administer your estate. I know that the old-fashioned common term is an executor, and in Oregon, what they call it, a personal representative. Mm-hmm. Tell us a little bit about what you're doing by nominating a personal representative and, kind of what they do.
Yeah. Yeah. So you can nominate pretty much anyone to be personal representative. It doesn't have to be a spouse or your child, or a family member or anybody or anything like that. It can be anybody. They just have to be over the age of 18. Generally, it can't be someone that's like a felon or anything like that as well. But a personal representative, at the end of the day, their main objective is to administer and manage your estate through probate in the event of your passing. And so they're going to alert the court as to all the assets that are in your estate. They're going to be the ones that's going to have to alert any creditors of your passing, give the creditors an opportunity to kind of make a claim if there is one, pay back your creditors, file your final taxes for the estate, and then do a final distribution of all your assets based upon your will, and the court rules. And so it's a job that will last, 4 months to however long. Sometimes some probates can go very long. Some probates can be relatively short, depending how streamlined things are in the estate is. But like I said, at the end of the day, their job is just to manage the estate. And they are a fiduciary, so there's specific rules and powers that they have, but things they need to follow just to make sure they don't do anything incorrect. And when going through probate, the personal representative usually will work with an attorney, and the attorney will, be able to walk them through the entire process and help them through everything. So they're not necessarily flying blind.
Acting in a fiduciary, that's important kind of thing you talked about. Are there any issues then with the personal representative, either, being a witness to the will or being a beneficiary in the will? Are they somehow restricted, or do they have to be someone off completely on their own, or what?
Yeah. So no, not inherently. The personal representative can also be a beneficiary. Their the requirements and the fiduciary obligations of a personal representative aren't diminished or lessened because they are a beneficiary. They still have to do things as if they weren't a beneficiary. They still have to take care of all the other beneficiaries that may be part of the will. And if they generally a beneficiary of a will or an estate, it on its face inherently doesn't necessarily invalidate a will if they were a witness to a will. If there's some other factual evidence to state that maybe there was some coercion or something along those lines, then you may have a question as to the validity of the will and the signing of the will by the testator. But just because they did sign it doesn't necessarily mean that the will is invalid. Now, from a practicing standpoint and just my own, kind of personal practicing philosophies, I tend to not recommend that a beneficiary be a witness, just so you can avoid those questions. And it goes back to the same thing we talked about earlier: remove all confusion if possible. And so, if a beneficiary never signed and was never witnessed, there's never going to be a question from that perspective that the beneficiary had some coercion or forcefulness for the testator.
Yep. Yeah. That seems like a great idea. So you talked about different kinds of bequests, which are basically the way the property gets distributed.
Mm-hmm.
And you mentioned specific bequests. Can you make a list? Is it like, here's a list of stuff that goes to Johnny and here's a list of stuff that goes to Jane?
Yeah, absolutely. And that's not an issue. And it's like sometimes, you'll add photographs and other things to make sure it's clear and indicated as to what you're actually providing. You're not going to be able to do something like everything in my bedroom will go to this person. And that may work, but you want to be able to list items. And like I said, make it clear as to what the item is and who it's going to. So again, there's no confusion, there's no question from by the court or anybody else. So you can absolutely make lists of specific things. It could be for personal property, it could be for vehicles, it could be for real property you own. That's, yeah, you can make any specific gifts you would like.
Got it.
As long as that transfer is not an illegal transfer, there's no issues.
Then you talk about residuary requests. A little more on that. It's because it seems like if you name specific items for everyone to take,
yeah,
and then some other item comes in and you haven't made some provision for that, you know, what the heck would happen to that? So how does that kind of fit into this residuary bequest?
Yeah, any asset that isn't specifically bequested or specifically gifted in your will fall into the residuary. And then you need to list a beneficiary of the residue of your estate. And then that beneficiary will inherit. It can be more than one person, it can be several people, and it doesn't necessarily have to be equal. It could be a percentage where, you know, 2 people inherit 40%, and then you have one person that inherits 20. And then at that point, it's just on them or on all the personal representatives to figure out how exactly that's going to be split up so the percentages work. But really, it's just everything you didn't specifically name in the will to show that it's going to be, it's going to fall within the residuary and pass that way. So you don't name a specific person to receive something. It could be like a vehicle. You didn't name a vehicle that's going to go to a specific person, but you own a couple of, you know, let's say it's classic vehicles, and you have 2 children, and you just say your children are going to inherit from your residuary entirely equally. Well, then it's possible that the kids can each get 1 vehicle. And that's a very simplified example, but because you didn't name a specific person, then it will fall under the residue of your estate.
You mentioned percentages, just made me think of a question. If, let's say you leave 50% to your 2 kids as your residuary clause, but you've also got some specific bequests.
Mm-hmm.
Are those specific bequests dealt with first, and then they get 50% of the rest of it, or is that 50% somehow include the value of that?
Yeah. The best way to look at residuary is you're going to look at take specific requests into, or specific gifts into account first, and then paying off any creditors and expenses of the estate, and then everything else from that will fall into the residuary or the residue of the estate. And then whoever is the beneficiary, or if there's multiple, they'll get their share out of that.
Got it. So what happens if you know, one of your beneficiary, you know, dies before, you know, the will is done? Or is there something that goes in the will that kind of discusses that kind of a situation?
Yeah, there is. And so you can have a clause, and it's more than times than not, you want to make some designation like this, especially if you have children and they have grandchildren and those types of things. You can make a designation, and again, won't go into details, but the phrase is with or without representation. And so the best way to explain this is, let's say you have 3 children, and you're going to give the residue of your estate to each of them equally. So they're going to get 33% roughly. Now, if you leave it to them with representation, with the right of representation, then if they were to pass away before you do, their share, their 33%, will then be split amongst their children. If you decide to move without the right of representation, then the share of one of your child who passed away will then be split amongst the other 2 siblings that are still alive. And so you kind of have this ability to kind of keep a specific share in a lane, and then it'll go down to their heirs, if they have any.
Yeah.
Now, if you list it as with the right representation and there are no heirs, then it still may possibly fall to the other siblings. But you have some ability to kind of keep a specific share of your estate within a specific lane of children or whoever it may be. But children, just to give the example. And then a situation that happens sometimes, you know, let's say you leave everything to your spouse, but you and your spouse may pass away at the same time in like a horrific accident. then you would ideally have some clause that just designates or explains in the event of like a simultaneous death, who will be ruled as passing away first, just for administrative purposes. And it makes things a little bit easier because then you don't necessarily have to go with the back and forth and argue as to how the court should administer the estates. Because if the spouse is supposed to receive everything, and then it goes to X, Y, and Z, and then on the opposite side, if husband passed away first and it goes to wife, and wife has specific designations under her will that are different from husband's, then it creates some confusion and maybe some contention on, other family members or people who think they may receive less if you don't have that type of clause to just explain that if both of us pass away, then husband will be viewed as predeceasing wife for administrative purposes. So again, it gets rid of that confusion we talked about earlier.
That it also, I think, saves money, it sounds like, because I remember in the old days, there used to be battles over this. Mm-hmm. Because, I mean, if there was an automobile accident, there'd be litigation on which of the couple died first, because it saves a whole estate from having to be probated and taxed and then doing it again.
Yeah, well, I mean, in these situations, especially in this day and age, with the divorce rate just being as high as it is, you're likely going to deal with a blended family. And if husband's will states that more of his estate or the residue of his estate is going to go towards his children as opposed to maybe his wife's children, and they both pass away at the same time, and it's viewed that wife is, potentially going to have passed away first, and all of her estate is viewed to go to husband, then it's possible that that wife's children could be disinherited in a sense. And so you're right; it will avoid a lot of litigation with proper planning. Obviously, that one clause is not going to save everything. You want to do additional things within your will, but it's something that can be done just to avoid some confusion.
Yeah. Let's move on to you mentioned minor children. And I know there's probably, several issues in your will that can touch that.
Yeah.
I know that like naming a guardian for your children sometimes does that. What does that really mean? I mean,
yeah. It's important to note that just because you name a guardian into your will doesn't necessarily mean that that's exactly who the individual will be who may watch your children if they're underage and you have passed away. We cannot pass children on to other individuals like property. And I'm sure everybody can understand why that's the case. But in the event that the child is in need of a guardian, and you are clearly the custodial parent, and there's no other parent that's still alive, then the court will try to heed your wishes as to this individual is going to be the person to watch over your children. Now, the person still has to qualify, right? So they still have to qualify under the Oregon rules as to being a guardian, being somebody that can actually watch the children, have enough of resources or the ability to watch children with home and et cetera, and not have, a felony record and that type of thing. So they still have to qualify, but you can nominate individuals that you trust and believe that could watch your children in the event that something happens to you and your spouse.
Which kind of leads into, leaving minor children money. I mean,
yeah.
How does that work?
Yeah. So if you leave minor children money, then in those situations, you can list what is called a custodian. And a custodian, its whole purpose is just to watch over whatever funds or assets you left for your minor child until they become of age, of a specific age. So 18, 21, 22, kind of depends on how it's listed and how you decide. And essentially that money or whatever it is going to sit in an account, or it's going to sit somewhere, and it's not going to be touched or used or done anything with without specific reason or without instruction until, like I said, the child reaches a specific age. You can do some other things as well and create some type of trust or testamentary trust as an alternative or on top of, but generally, to get over something like that, you would just, you can create a custodian. And it's different from a guardian because the guardian is literally watching the child and the child's welfare. The custodian itself is literally just making sure that these funds or whatever it is are safe and will be ready for the child once they reach a certain age.
I know on some of our past broadcasts, we've talked about the difference between wills and trusts and
Yep.
what they are and what they do and what their purpose is and the strategies. But I guess the question is, can you put a trust into a will?
Yeah, you can. And that's what I mentioned earlier. That's a testamentary trust and just states that, a share of part of your estate, whether it be residuary or some other type of specific gift, can be placed in trust for an individual like a minor child. And that trust isn't, quote unquote, alive, doesn't become in existence until the testator becomes non-existent. And so it will essentially just sit dormant until the administration of your estate. And then once probate is completed and distributions are going to be made, that distribution will be made into the trust that you have put in within the will itself. So it's a good hybrid type of option that some families will use if they don't want to create and manage like a living trust now.
So we've talked about all kinds of things, all kinds of provisions you can put in your will, and it kind of sounds like some of them will be followed as long as everything's done legally, and some of them may be followed because they're like wishes, but don't necessarily mean that will happen. And it seems like it's important to know the difference between those two when you're making a will.
Yeah, absolutely.
So then you made your will, and the question kind of becomes, it's an important document. It may speak on its own years from now. Any advice on what people should do once they've made their will with their will?
Yeah. So obviously you want to keep it in a safe place. There are alternative ways to present a will to the court in the event of your passing if the original is not there. But again, we want to remove all confusion. So we want to keep the original will in a safe place. So that could be with your attorney. It could be, if you've got a safe or a safe deposit box or anything like that, you want to keep that safe. And then normally if the client is the one that holds the original, the attorney will have a copy just in case that is absolutely needed. But yeah, you want to be able to keep the original safe and with you so you know where it is at all times. And then, if there's ever any updates, let's say you have a codicil or something like that, then you just want to make sure that document gets added to the rest of your documents as well in a safe place. In some respects, you could record the will in the county in which you live, but that's not necessarily a super common occurrence, but it's very possible.
Yeah. You briefly mentioned updating, and we've talked about this on past broadcasts, but maybe you could just kind of quickly run through again. What are the highlights? How often does it will need to be updated?
Yeah, I would say every 3 to 5 years, you want to at least just look at it. Not say you need to go and call your attorney again or do anything. Just look at it and make sure everything still makes sense. The things you still have there, you still own. There hasn't been any significant changes. And then, as always, it's any major life change. You have a new child, you decided to retire, you buy new real estate, sell previous real estate, a death of someone in your family, whether it be a spouse or a child, maybe even grandchildren is a time there to look at everything and potentially update it. So yeah, major life changes in an individual, it's going to be really important to look over your will. You get an inheritance, like a significant inheritance. You get a divorce, you get remarried. All those things you want to relook at your estate plan and your will, just because that life change may require you to make a change in your documents, depending on how it's drafted and depending on your wishes.
Yeah. So one last thing. You talked a little bit earlier about wills and probates. And so you're not making a will and having it be valid and all that stuff. That's not really the end of the story, is it? I mean, wills, you can't just take a will when someone dies and just go out and run with it and do stuff. It doesn't automatically transfer property, does it?
Right. You're correct. And so just because the will's written and it's valid and it's executed and it's been witnessed and the witnesses attest to their signatures and all of that, doesn't necessarily mean that the personal representative, because they're listed on there, can then just be like, well, this person's supposed to receive X and this person is supposed to receive X, and then the residuary goes to their children. You can't then just start giving them things. You do, the estate and the will need to be probated. Essentially, that means you have to petition a court, which is a specific document that goes to the court that says this individual has passed away. This individual is being listed as personal representative within the will. Here's a copy of the original will. We need to open a probate for the estate so we can begin to distribute the assets and manage the estate per the will and per Oregon laws. And the court has to accept all those things before anything can happen. And there's a myriad of things that happen within probate, and maybe that will be another cast we can talk about. But generally within the probate process, the court accepts the will, this is valid, and then the personal representative who takes and accepts that role will make sure that the creditors are paid, their last final taxes of the estate are paid, and then once all the expenses and all the creditors are paid, and after specific other things that are happening, this is just a simplified version, but after all that is paid, then a distribution will be made to all the beneficiaries and the individuals who are going to inherit from the residue of the estate. At that point, then the probate would close, and then that the personal representative's role is complete, and then the will's wishes are complete as well.
Well, we're running out of time, coming to our conclusion. This was wonderful. I am going to ask you one last real quick question. You can just give us a yes or no on this one, because I get this all the time. Can I put a clause in my will that says if anyone contests it, they're out? You used to call this the terror clause.
Yeah. I mean, it's not something I see super often. What I will say is it's possible, but it's something else that is just going to be contested, especially because it's going to be like children, and it doesn't necessarily mean, I won't say it's guaranteed that it's just going to stand as is, but I've never had to write a clause like that into any estate plan that I've done. But as far as I know, it can be done. I've just never seen the outcomes of those types of issues.
That's kind of a blast from the past.
Yeah, you are able to disinherit people, but I would choose a different way to do it.
Yep. So Triston, thanks again for joining us today. And I mean, demystifying just, what the heck wills are all about. Your insight, to the world of estates is impeccable. Yep. And, your ability to make this complicated stuff understandable is really much appreciated. Thank you.
Thank you. Thank you for having me. I'm glad to be here as always.
You bet. And I look forward to next time. So I also want to thank everyone else who turned in today at Facebook Live. And again, anyone has a question, anyone wants about what we talked today or about getting a hold of Triston and having a consultation, you can post it here. You can shoot me an email at steve@landerlaw.com. And until next time, everyone, stay safe. Have a great day.
Well.